Hello, welcome, Marie. How are you doing?
I'm fine, thanks, Alison. How are you today?
Fantastic, fantastic. So today, tell us, what are we going to be talking about?
So today we're going to be looking at returning to work, sickness absences, and how to get people back into the office if you need to, and to encourage people to come back to work who might be stressed or anxious about it, for example.
Absolutely, fantastic. All right, so tell us a little bit about you and, so how you know so much on this topic.
Okay, so I'm a director and owner of Consilia Legal. We set up about 7 years ago. We've now got offices in Leeds, London and Harrogate, and we specialise in employment law, and I've specialised in that area for 20 years now. So I act on behalf of a lot of big companies, small companies and employees. So it's generally my bag. I get it from all areas, really.
Fantastic. And don't you do some work with kind of colleges or something like that as well?
Yeah, we do a lot of work with private schools up and down the country, which is quite nice. So yeah, lots of different areas to explore there in terms of employment and boarding and lodgings, and it's a really nice area to practice in. So I'm very lucky.
Oh, amazing. Okay, we have a mutual friend who's Kelly, and that's how we became connected. So that's fantastic. Kelly is one of our clients as well. So, and I've known Kelly for 16 years or something.
That's
I think you've
right.
known her a bit longer, haven't you?
Yes, yeah. I've known her since school.
Have you?
Yeah, we went to school together. So yeah, it's quite. You never lose touch with your school friends, really, do you?
No, we try, but no. Okay, so thanks so much. I can see there's people on the line today, so that's brilliant. We're going live on LinkedIn, live on YouTube, live on Facebook. So hi everyone, welcome. This will stay up on the stream after today. So bear with us while we do technical things. Yeah, we're going to go through some 5 steps. Marie prepared 5 steps. But what is really important, I can see you on the line today, everyone, is we've only got sort of 30, 35 minutes at the max. So any questions, please do ask, because we're able to do this very clever thing where we can do this, where, as an example, we can put questions up. So please do either put nice comments or welcome comments or whatever you want into the comments box, and I should be able to technologically share it. So if you can do that, that would be great, everybody. So what are we doing here? Let me just see. So we are talking about 5 long-term sickness absence considerations. And post-furlough, tell me, Marie, what was it post-furlough that made you, what's the difference really?
I think during furlough, if employers have had issues with individuals who have needed to take periods of sickness absence, what's really been happening in many cases is they've been utilising the furlough scheme to sort of put that on the back burner while they address the imminent issues, maybe at work or with people who are in attendance. And with the scheme coming to an end, we've received lots of inquiries about, well, how do we deal with this if the person cannot return to work, or how can we facilitate somebody's return to work, flexible working? And it's become quite a hot topic, particularly at this time of year as the furlough scheme's winding down.
Yeah.
So it's something that's now on the front rather than the back burner, as it were, and seems really relevant just today to have a chat about it.
Absolutely. I mean, it must be very hard for employers to keep in touch like they would have done under normal circumstances. Organisations would have kept in touch with their employees. It would have been a much maybe easier transition into potentially, absence management processes. Whereas now there's been such a long break.
That's quite right. And also because of the furlough scheme, a lot of employers haven't been keeping up to date with employees' ailments, up to date with their health, because they've not been requiring medical certificates because they've been on furlough. So it's at this time of year people are starting to get back in touch, and the inquiries are coming through on both sides actually. So employees as well saying, what can I do? How can I help my employer understand my needs and what are my rights? So it works both ways.
Yeah, absolutely. So just a little reminder, welcome to everyone who's on the call. I can see the number of people that are on the call today, so that's fantastic, very exciting for us. I do urge you to put some questions in either YouTube or in the comments or on LinkedIn. Please do put comments because that really helps sort of stimulate our conversation. So yeah, this is Marie. We put her details there. So there's her contact details if you need those after the event. And Marie also said that she's got a sort of fact sheet she'd also be very happy to email out. So you just need to jot her details down there or do a quick screen grab so that you can get her details. So on to the first point. What we're going to do is we'll move away from having the slide up to just having you up or whatever we do. So in case you're wondering about that. So tell us about this. What are these 5 steps? Talk us through.
Okay, so I mean, it's pretty straightforward. A lot of these issues are about common sense on both sides and a bit of practical application by the employer and the employee. And so many times we have inquiries from employers and we'll say, well, what is the issue? And so, for example, they may say, and this is one of the bigger issues at the moment, oh, there's stress and anxiety.
Yeah.
And I'll say, what does that mean to you? And the problem is that means so many different things to so many different people. And it's very dangerous just to make a sweeping assumption that it's the same for every person who suffers with stress and anxiety. There'll be differing levels. They might be describing it as a different illness. So what we say, first of all, is, you're not a GP, you're not a medical professional. In order to understand somebody's needs, and legally, really, what you need to do is obtain their consent as an employee to access medical records. And that doesn't mean, medical records going back 20 years and the eye through the needle on every issue they've ever had, but what's affecting them now, how they can be accommodated, are they fit to work? If they're not fit to work, are there any adjustments that can be made? And we'll touch on that later. And also whether that person might be disabled for the purposes of the Equality Act, because then they do have other rights. And it just would help if you can get either if you've got internal occupational health reports.
Yes.
Even basic things. If you're a smaller business and you can't afford to get a full belt and braces report or you're short of money, there are things that you can do internally, for example, stress risk assessments. You can download those from the Health and Safety Executive website. They're free. And they're also split into helpful sizes of your business. So, that's a free resource. So there are steps that you can take, but the most common one is either approaching somebody's GP, internal occupational health, or an external occupational health therapist.
But hang on, Marie, now because a lot of our customers are actually small businesses, so obviously having the luxury of an Occy Health team is maybe not something they have. But would we have needs to have written this in the employment contract that we had the right to seek this information?
Well, you can do, and a lot of up-to-date employment contracts do contain a provision that says that at the request of the company, an employee will submit to a medical examination, and failure to do so would leave the employee in breach of contract. However, in practice and on the ground, if you can approach an employee whether you've got that right or not, and ask for their consent. And most employees, in my experience, will consent in legitimate circumstances. There are special forms to fill out. Obviously, there's GDPR to consider. Yeah. And I'm not really a fan of writing to somebody who's unwell and saying, submit to this report or you're in breach of contract, because that often doesn't help somebody who's absent with, for example, stress and anxiety. Yes. So what we try to approach it in a more collegiate way, because it's in everybody's best interest for the person to get back to work. Yeah. I've very rarely met an employee who doesn't want to work. I mean, I have met a few in 20 years, but not many. Most people do really want to get back to work.
Yeah, it's tricky, isn't it? Because what if people are not, what if people are not responding to that first request? So if they're not reading their email, or what do you think about that?
Well, there's lots of different ways to contact people, and in employment law, really, the main gist of everything is reasonableness. Have you been reasonable? What steps have you taken? And everything's judged in light of the size and resources of your business. So if you've got a small business, you're obviously not expected to take as many steps as ICI, for example, or a multinational. And if ultimately an employee will decline to give any sort of access or engage with you in a process, well, what the legal position says is that you can only act on the information that you've got. and be reasonable in the circumstances. So that doesn't really benefit the employee either. If they genuinely want to make you aware of the position health-wise and help with a return.
Yeah, okay, all right, that's really helpful. So would you suggest making phone calls? Would you suggest email, letters?
Yeah, quite right. So ask the employee how they want to be communicated with. So, you know, a quick phone call to ask, you know, are you okay? Some people offer home visits if the employee is happy with that, or meeting in a neutral third party venue. You know, they arrange meeting rooms somewhere. That nowadays, obviously, and since the pandemic, there's a massive increase in the use of technology. So it could be Zoom, WhatsApp, FaceTime, anything that somebody's familiar with, to put them at ease, and make sure that all those methods are offered and that the employee has a say in how they want to be communicated with. I think that's key. But ultimately, there is a right to communicate, obviously, in the relationship. So
unlikely that employers would do this, but I just wanted to check. So what about recording phone calls and things like that, if they were having those phone calls with employees?
Well, you should probably make it known if you intend to record the phone call. I have had this in a number of different scenarios, however, and recordings are admissible in proceedings,
right?
Even if somebody is unaware. So it is more common nowadays, but normally, obviously, we still stick with minutes of meetings if it became formal rather than recordings. But it is becoming more common to record.
Yeah, okay. All right. So if we're talking about occupational health, I mean, people on the call might not know what that means. So talk us through from your perspective what you understand that to mean.
Okay, so I'm not an occupational health. I'm not an occupational health therapist. However, there are a number of occupational health service providers, and what that means, it's people who are qualified and can advise as to whether employees are fit to work and what adjustments and any other assistance you should or could provide to them to get them back into work. So it's all around work from my perspective and in relation to this call, and how we can accommodate people. Now, I similarly to you, Alison, a lot of my clients don't have internal occupational health. A lot of them, the smaller businesses, might not know, but they probably will, with their insurers, have an employee assistance helpline somewhere. And so you should always check whether that's available, because it's a good sort of freebie that you can make people aware of. But in terms of occupational health, there are a lot of independent providers who provide reports at a very reasonable rate.
Okay.
And so we've got contacts with quite a few different ones. You know, it's horses for course, a bit like employment lawyers, really. So if you can get a good relationship with an occupational health therapist and you like them and you think they'll be good, you can refer to them. I'd say average cost a couple of £100, maybe a bit more. But in my opinion, it's a thorough report, and it's often more effective than a GP report. What we're finding at the moment, and I'm the Employment Lawyers Association rep for Yorkshire and the Humber currently, and my members and I are finding that GPs are very reluctant to give these reports at the moment.
Because of time, or because of what?
I'm not sure. We can't seem to get to the bottom of it, but we seem to be getting a lot of knockbacks saying we won't be providing this report, or seek specialist occupational health. And on some occasions, not to be critical of the GPs at all, but we will just receive a report, or have received reports that just repeat verbatim what the GP has been told by the employee, and they don't really go any further to assist the employer in getting them back to work. Some do, but a lot don't.
I guess the thing is here, what if you're a cafe owner and it takes a lot of cappuccinos to make £200 for a report. So is it absolutely essential that they do this type of thing?
It's not essential. As I say, you can only act reasonably in light of the size and resources of your business. So if it was cost prohibitive and, it was impossible, you can always liaise with the individual. There's good old fashioned talking to each other and communication with staff, isn't there? It's just that if it's something a bit more serious, and it might, for example, be a disability or something, longer term that they need help with, it's just sensible.
Yeah. Okay, that's really, really helpful. So the next one that you had on here was about, is this slide? Do you want to talk through that?
Yeah, happy to. So reasonable adjustments, this goes back to what I've been saying about whether a condition amounts to a disability. So under the Equality Act, I know a lot of people will already be aware of this, but just bear with me. A person has a disability under the Act if they have a physical or mental impairment, which is or is likely to be long term, and which has a significant adverse impact on their ability to carry out normal day-to-day activities like getting dressed, going to the shops, that kind of thing. So if an individual has, let's say depression, and that depression, is a mental impairment, they've had it for 2 or 3 years, so it fits the 12 months or more, or it's likely to last that, and it does affect them. And this is in the absence of medication. So we don't look at the effect of the medication. It's without any assistance, for example, antidepressants, would this have the effect? Then they might be disabled for the purposes of the Equality Act. Now, if that is the case, the Equality Act it places a legal duty on employers to make any reasonable adjustments to accommodate that individual. And employers have got to take steps as far as they reasonably can to assist the person. And reasonable adjustments, there's lots and lots of guidance on that. It's actually in the fact sheet, so I won't read them out because it's a bit dull. This is a bit of a chat.
But also, when I was doing some research, I found Mind, this charity, had a really good pamphlet there, so you can look it up on what the workplace adjustments should be for mental health individuals.
Yeah, so I mean, in terms of mental health, there are so many different things, and actually just talking to the person, they can probably tell you what would help, things like regular breaks, different working patterns, maybe it's short notice holidays if that can be accommodated, or there's lots of different ways that this can be dealt with. And it's just a matter, I think, of thinking of all options and outside the box.
Yeah, absolutely. And absolutely. So here's our next slide, which is, I don't know why it's doing that. Is it flashing for you? It's flashing a bit there.
It's a disco slide.
I don't know. There we go. So talk us through, and by the way, just guys, I'm noticing we're very quiet on the questions front today. So do please give us some questions for Marie, because she'd love to answer them. So talk us through step 4, Marie.
Okay, so one of the questions that we get asked a lot is, obviously because it's legal and people are frightened of employment tribunals, is, look, we've got an individual and they do not want to come back to work, or say they are not fit to return to work. And a lot of people adopt the ostrich approach here and think, I can't deal with it. Somebody's unwell. The best thing I can do is nothing because I'm frightened. And actually, the best thing you can do is not nothing in those circumstances. That it's in those circumstances that litigation arises, in my opinion. If you haven't already got one, there are lots of different processes and procedures out there, precedents, but a good capability procedure, if somebody is not able to return to work, is something that you should go through. Now, this is whether they've got over 2 years service or less than 2 years service, because discrimination is a day one right. So if the person is disabled, you don't want to simply part company and not have carried out a fair process. But in terms of a process for capability, what this normally consists of is sort of speaking to the person and getting any medical evidence, trying to get them back to work, a series of meetings at which they can be accompanied normally by a trade union rep or work colleague, a two-way communication programme during those meetings, attempts to return, they could be temporary, you can have trial periods. It might be additional training. It might be that there's other support out there that you can offer, as I said, employee assistance, or it might be that they're having counselling, or, there's lots of different things to consider. But ultimately, if somebody isn't fit to return to work and there are no adjustments that you can make to accommodate them, then you are entitled to part company with an employee. And the reason for the dismissal in that case would be capability. And capability is one of the 5 fair reasons in the Employment Rights Act to dismiss. So it's not a fast process, and rightly so, because obviously the individual should, you don't just immediately get better if you're unwell, do you, and jump back into the workplace. But over a reasonable period of time, it should become apparent whether you've done everything you can or not, and whether the individual is able to perform the duties.
So that's really helpful. I'm just going to, sorry, it covers your face, Marie, because the question is,
That's fine.
it's very big. It's not personal. But thanks, Adiam, for putting this question up. What is the company supposed to do in the case of an employee who's been employed for a year and a half, has already taken 100 days off sick due to anxiety or other health issues, considering the company is now considered occupational health GP, specialised in mental health, to do a report? How should the employer move forward? What other actions could they take, considering the employee that's considering the individual has not been able to perform their job so far? I mean, I think you've answered that, but anything specifically extra you'd like to say?
No, not at all. Apart from the fact that 100 days is a lot of days before action. And this goes back to my point about people not addressing issues early doors. What sometimes happens is if you've got a company with a particularly generous sick pay entitlement, or sometimes in local authority public sector, they tend not to touch or to liaise with somebody while sick pay entitlement is ongoing, which always seems like a completely false economy to me from both sides, because the individual won't want to be off work for 3 to 6 months with no contact, and the company, for example, in that case, is missing out and not able to, refill or fill the role effectively. So I think I probably wouldn't have left it that long, but given where it is, it's following the capability process, which should be in a handbook. And if you're not engaging with lawyers, or there's a cost prohibitive issue there, you can always go to the ACAS website. They've got some fantastic processes, procedures on there. And that it will guide you along. And the ACAS principles are quite persuasive in tribunals if you're ever challenged, because at least you followed good practice.
Yeah, that's good to know. That's good to know. So, I don't know why that's doing that. Just that's our last step, really, is what is actually the process.
Okay, so in the process itself, as I said, probably 2 or 3 meetings spread over a period of time. In terms of getting somebody back to work, you should set clear targets about, how that might happen. Make it clear what they need to do, how they can accommodate that, who they're reporting to. Make it feel safe, not a threatening procedure. Some people use a capability procedure as a bit of a threat to employees, and it shouldn't be really. It should be a supportive process where the individual can achieve targets, and in targets I might mean, try coming in 2 days a week, then try 3 days a week, or try 1 day a week. Set tasks that might not be the full job load at first, allocate to other fee earners or workmates, for example, but then build up gradually. And if you can demonstrate that you've also, if you can provide additional training, if that's needed, as I said earlier, maybe internal stress risk assessments, which might be ongoing, and any other assistance that the employee may request, as long as it's reasonable, obviously, and not beyond your capabilities as an employer, then the process, I think, on average, a good process takes between 3 to 6 months as a minimum. Which
is a long time, isn't it? Let's be honest. If you are in retail, in casual work, it's quite painful, isn't it?
That's right. And I mean, I do have some employers, Alison, who if employees have under 2 years service, they don't do that. So they make the process shorter because, under 2 years, effectively, unless there's a discrimination point or whatever, there's no right to bring an unfair dismissal claim. And if the person's not disabled for the purposes of the Equality Act, then it's not challengeable, arguably. I mean, obviously that's a sweeping statement, but, a lot of the fear around capability processes is the Equality Act, because the damages are unlimited. So, if you discriminate against somebody who does fit the criteria, either by failing to make reasonable adjustments or dismissing them, for example, because for a reason relating to the disability, and that might be performance or something else, then you can get caught. So I think that's why people take a little bit extra time with sickness absence dismissals.
So remind us again, the Disability Act, with stress and anxiety, you mentioned something about medication. Just remind me again what that was.
So in terms of whether somebody's suffering with a disability, and this is why I like medical evidence, the Equality Act defines a disability as a physical or mental impairment which has a substantial adverse impact on somebody's abilities to carry out normal day-to-day activities. In other words, it impacts your life in a substantial way, and it's lasted for 12 months or is likely to last for 12 months or more.
Okay.
So in terms of medical evidence, obviously it's not possible for us as lay people to ascertain whether somebody's ill or not. It's obviously a medical issue.
Yeah.
But what I said about the medication is, if, for example, I was suffering from chronic depression, but functioning quite happily because I have received the right medication, or say I have bipolar and I'd had my ups and downs, but I'm now on a good level of medication. When they're assessing whether I'm a disabled person for the purposes of the Act, they do it without taking into account the medication. So it's what would I be like if I didn't have those interventions?
Right. Okay. That's
so
very
it's not,
interesting.
they don't say, well, she's all right now because she's
Okay.
medicated. That I could still be a disabled person for the purposes of the Act.
Yeah, Malcolm makes a good point here. So he says, my experience is that you also have to keep other staff up to date. They often resent other staff doing less than they do for the same pay at the same time, and they have to up their game to cover for them. You know, because you still got a finite amount of money, haven't you?
You have, and it's a really difficult one, is that, because obviously you've got confidentiality obligations towards the employee who's unwell or unable to work, but at the same time I do think a lot of that comes down to culture. So, you know, in the culture in a lot of places, if you can, like you said, if you can keep the communication going without breaching any confidentiality and everybody's supportive and you've got quite an open culture, that does tend to work better.
Yeah, that's really interesting.
And sorry, Alison,
No, you go.
Well, the other interesting point, which I've not mentioned, is I do a lot with the CIPD, and what I found is that a lot of people are doing mental health first aider training now, or having somebody who's mental health first aid.
We offer that.
Yeah, and yes, of course, yes. And what I found quite interesting is the number of people who have said to me that they prefer it if that person isn't the HR person, or there's another person in the organisation, because they fear HR for some reason. And even though everybody I've ever met in HR is lovely, but
they sometimes know too much.
Yeah, and sometimes, you know, for employees, it's easier for them to speak to a colleague who just does that, who is just there as the mental health first aider, who can, you know, is approachable, they don't fear reprisal, dismissal or anything, even that if that's not on the cards. So that's quite a good tip.
Yeah, so it would not be an employment law thing if we didn't share our disclaimer. You know, I don't know. It's so, no, this is guidance. It's not intended for legal advice. So we prepared this earlier in September. So if there's any, you know, we just like to protect ourselves there. And really, it's this is the next live stream we will be doing. And that's going to be about on the 13th of the 10th at 11 a.m. as well, again with Marie, and we're going to be covering restrictive covenants. But before we finalise, is there what would be your top couple of things for people to take away today?
I think communication is the top thing for me in all sense. Most people, as I say, do want to work. There is a lot of anxiety around work at the moment, you know, returning to work. There's a lot of genuine stress out there. And I just think communication is my top tip. That you can never be criticised for overly communicating, you know, your concerns and trying to help. So the more you can do, the better, and don't just shy away from it.
Yeah. Well, that's amazing. So, well, we look forward to our next live stream. As I said, that is going to be on the 13th of the 10th. We're roughly doing these every 2 weeks, and we do the other. So please do subscribe to our YouTube channel because we put these up here. We do webinars, which we also put up, and we've got some other how-to guides. If you've got any comments or questions, we've already said pop them up there. So we've got, thank you. Someone says really useful session to learn more about how employers can support staff with long-term stress and anxiety. So thank you for that that person. If there's any comments or any subjects that you think, as our viewers, that you think would be really useful, please do tell us, because we just came up with some random ones. What was the other one we were thinking of doing?
I can't remember now. I can't remember now. I can't remember, Alison. But we're happy to do anything. So I can waffle on about any area for at least half an hour on most issues. So, if you, at the moment, the restrictive covenants one is relevant because I've got a lot of employers who are looking at the contracts, people coming back from furlough, for example, and leaving, and their restrictions are not fit. So that seemed like an appropriate one. But there's so many different issues. So if there's something that you want covering, I'm more than happy to cover it if you just let Alison know.
Absolutely. And thanks to Jennifer, who's put a lovely comment up there. Thank you. Great tips. Feel free to leave some other comments. And it's just been lovely to go live with you, Marie. We look forward to other sessions.
Thanks for having me, Alison. See you soon.
Right. Thank you. Bye-bye.
Bye, everyone.